Next matter on the calendar is number 88, matter of Wang v. James.
Good afternoon, Your Honors. May it please the Court. Andrew Borelli from Gale, Gale & Hunt LLC on behalf of Petitioner Appellant June Wang. I'd like to reserve 2 minutes for rebuttal, if I may, Your Honor.
You may.
Your Honors, this appeal really turns on one issue, and that's the issue of request, whether Dr. Wang was acting at the request of the Department of Corrections when he...
So what would be the outer boundaries of your rule? So how many individuals might be entitled to the defense and the indemnification protections? How far down are we going to go? How many more tests? How many more lab reports?
Yes, Your Honor. My proposal for the test here is really just those necessary ancillary medical services to a procedure that's already been approved by the Department of Corrections. Particularly those where it's an indivisible part of the procedure. For example, here, a biopsy necessarily contemplates a pathology review.
Does it matter whether or not they have the right to voice whom they wish to use for those procedures?
Your Honor, well, I understand that's the state's position. I would say not here, not when they have not when they've conceded that yes, we've approved a biopsy. They take the trappings that come with that.
So you're saying they should be bound, but they get no voice as to who provides the services of the biopsy.
Under the facts of this case, that's correct.
So, for example, before a surgery, you need to take everybody's blood to make sure, that sufficiently it's going to coagulate, or that it, that they're not HIV positive. It's an ordinary routine pre-surgical procedure. You take a blood sample. That gets sent off to LabCorp, a huge corporation. That's a necessary part of the surgery. Is docs indemnifying LabCorp?
I would say in that scenario, Your Honor, that if it's done pre-surgically as part of standard pre-testing, then that perhaps docs might be. I'm not saying it's unequivocal, but in this scenario with these facts, they're so inextricably intertwined, the biopsy is meaningless. The Department of Corrections says we need to figure out if there's malignancy. The only way to do that is to have that pathology review.
What if what if one of the surgical instruments, for example, had been contaminated, and that's something that is simply provided by some external third party? There too? I mean, I'm trying to understand where we draw a line here under your theory.
No, Your Honor, I wouldn't necessarily agree there.
So why would those lead to different results? Why is the pathologist who is not identified in any contract be performing this at the implicit request of docs, but not someone who is providing surgical instruments?
Well, Your Honor, again, with respect to this particular scenario, while a surgical instrument may be used during that procedure, here docs expressly knew that there was going to be a pathologist that was going to review it. They've conceded that.
But that's true too. If I'm going to perform surgery, I'm going to need, I'm not a doctor, but I've watched enough TV, I'm going to need a scalpel, right? I'm just trying to understand what makes something inevitable, which I sort of take to be your touchstone, although tell me if you think otherwise.
No, Your Honor, that's correct. Where is that inevitability? Yes, the Department of Corrections should be held responsible for that provider or
So a
individual.
slightly different approach to this overall question of what's your test. I understand your inextricably linked theory that you really don't do a biopsy without a pathology report to go along with it, but that's not what Section 17 of Public Officers Law requires. They ask at the request of, or maybe that's 24A, So how does your inextricability argument satisfy the requirement of the statute, which says at the request of?
Because requests in section 24-A of the correction law doesn't indicate whether it has to be express or implicit. That language
Doesn't it
is
at least suggest that there's some minimal contact between the parties?
I would agree, Your Honor, except for the statute also says any person, and it doesn't require an employment or contractual relationship. And so therefore, if the legislature wished it said differently, it could have changed that because public officers law clearly says
Wouldn't that be a
employer,
perfectly,
employee and independent contractor.
wouldn't the employment/contractual relationship requirement be a perfectly reasonable limitation on the application of the statute, especially given the fact that we're talking about a derogation of a common law principle of sovereign immunity. We have to construe it narrowly. And I think I get the impression from hearing some of these questions that you want us to go down a very slippery slope.
Well, Your Honor, with respect to that, I don't disagree that that would be reasonable, but that's not the way the statute is written. And if the legislature, and if the language needs to be different, then that's up to the legislature.
So again, you're suggesting there is no end. Anything that's related to the initial procedure, everybody gets the protection of the public officers law.
That's not correct, Your Honor. If I may,
Okay, so where is your cutoff? I'm just not clear.
well, first of all, if we look at section 24-A of the correction law, it has to be an individual who's licensed under one of those sections. And that may also go to Judge Halligan's point about the scalpel. And if we're talking about a third party providing instruments, that person may not be licensed under there. So first, we're limited by the individuals underneath 24-A. Secondly, I think the boundaries could again be that in a divisibility test, and to provide a couple of examples. For example, let's say the Department of Corrections determines that an inmate is having what appear to be signs and symptoms of a stroke and sends the inmate out to an outside hospital. And they want to know, did this patient have a stroke or is the patient having a stroke? And a way to do that would be to perform radiology imaging. And I would argue that that would have to be covered by the Department of Corrections, the radiologist who interpreted those films. But let's say during the scope of that workup for stroke, they discover a cardiac issue with the inmate. And ultimately the patient or the inmate ends up needing a bypass. And let's say something goes awry in that bypass. I would not argue that the Department of Corrections would be on the hook for that cardiothoracic surgeon because the Department of Corrections never asked for cardiac workup to be done.
Are you saying that once the initial request for medical services provided is that medical services be provided at the request of just keeps spiraling onward?
No,
So
maybe I'm not clear.
what does at the request of mean with respect to your client?
With respect to my client, it's that test that he was not involved, if the department would not have been involved, if the Department of Corrections had not asked for this biopsy to be done.
So
But to that, sorry, just quickly if I can, aren't you really reading out while acting at the request of the department? It seems to me if your view of 24A is correct, then it would have ended by saying the provisions of Section 17 shall apply to a licensed person who is rendering or has rendered professional services authorized under such license, which would cover any medical services provided by a licensed individual. So what meaning does acting at the request of have under your interpretation?
In my interpretation, it is that very point that in this scenario, because there's a part of a procedure that is inextricably linked, that is the reading. And I think in the example I've given, if you take it further, and even if it was after an operation in the hospital on an inmate, and the patient developed an infection after a hip surgery, let's say, I would not argue that the infectious disease care that would be needed to care for that inmate would be covered by the Department of Corrections.
That's
It's
I
so
can
closely linked.
This question, if I understand your opponent's policy arguments here, the state wants to know who they're contracting with. It may be an incentive to get people to go into a facility to do certain work. What is the policy benefit of reading this your way?
Policy benefit to my client?
Policy benefit, I understand it's money, but what's the policy benefit of us interpreting it the way you want us to? I mean, I assume your client has malpractice insurance. I assume he isn't incentivized to do this work because of some arrangement. So this seems to me an ordinary course request, comes from another doctor, you do it, you get paid. So what would be the policy reason for us to substitute the state as the insurer here?
Because the state should be defending and indemnifying my client for work that he's.
I understand that's what you want, but why should we do that?
Of significant damages that might go beyond the policy, his malpractice policy limits, the state certainly has further coverage. And so it
That's
should be-
true of any malpractice action your client may have, right? I mean, it may always go beyond the policy limits. It's not unique to a state client here. So I'm trying to understand, again, because I can see state needing to know who they're contracting with, needing to verify, needing to provide incentives for people to do the type of work they're doing. But those don't apply here with your client. None of those reasons. They didn't get to vet your client, and they didn't need to provide an incentive for him to do work for the state.
Respectfully, Your Honor, with respect to the vetting, I mean, it's because of the way the statute is worded. It says any person. Doesn't require that contractual relationship. Doesn't require an employment relationship. So the state has...
Let me try what just Judge Garcia is getting at a different way. Your client gets pathology samples from all over the place, some from prisons perhaps, but also from hospitals and general public and other physicians and so on. And I assume he's indifferent as to where they're coming from, right? He's going to do the best job he can regardless. He's not really even paying attention where they're coming from, right?
That's correct.
So then why would providing a state indemnity affect his behavior?
I don't, it wouldn't, I don't
Right, he's going to
disagree
continue.
that it wouldn't affect his behavior. He should be performing
Right.
his services.
He's going to
always
perform
will.
them as well as he performs regardless of where the sample is coming from.
Correct. I agree with that.
So then what is the public policy benefit of providing the state indemnity versus the private indemnity through insurance?
Because I don't, it's simply, Your Honor, that if he was acting, if he was performing this service on behalf of an incarcerated individual, he should be receiving the benefits that, for example,
That's not the
Dr. Cote
statutory
received.
test, counsel. The statutory test is at the request of the department, not on behalf of the patient. And, without asking the same question for a third time, how does the state benefit from expanding its liability coverage in this way?
Well, I'm sure, respectfully, I'm sure it costs the state more money to defend my client, but they requested this biopsy. They said he needs it. We need to understand if there's malignancy, and the only way to do that is to have a pathologist look at it.
Let me ask you this. Would it be possible for somebody in your client's position, let's assume for a moment we rule against you. Would it be possible in the future for your client or somebody in your client's position to insist on a contract with docs if they're going to do pathological work for people who are incarcerated?
Yes, certainly could ask for a contract if they so chose to go down that road.
So that there is sort of a contractual, even if we were to rule against you, and of course that doesn't help you in this case, or your client in this case, but in terms of a rule going forward, it's something that can be contracted around.
Yes, it could, Your Honor, but the fact of the matter is the statute doesn't provide for that necessarily now as it's written today. I mean, yes, they could privately do that, but I don't think that's necessarily required. Thank you very much, Your Honors.
Good afternoon, Your Honors. Kevin Hu on behalf of the Attorney General's office. The Attorney General reasonably and correctly concluded that Dr. Wang is not entitled to the benefits of Section 24A because docs did not expressly and directly request that he provide the pathology services at issue here.
Counsel, what if he says, what if his client in the future and all in that situation, going to the Chief Judge's question, say, I'm not doing this.
Judge Garcia,
Indemnify me, I'm not doing it.
If we could sort of play out the downstream consequences of affirmance here. So
No, but answer first my question. So what if they say, I'm not doing this. I want to contract with you, and now all your biopsy work and I guess other potential work is stalemated. Is that a good result?
That is a good result because
It is?
it would ultimately lead to an outcome that is consistent with the legislative purpose of Correction Law 24A. So in that outcome, one of two things would happen. Either pathologists would come forward and demand a contract with the state, and we would then agree to provide them with these protections, or the state may proactively seek out these individuals. But the key factor in both of those outcomes is the state then has the obligation, and then has the opportunity, to seek out particular individuals and weigh their credentials, qualifications, and the potential risks they propose.
And is it the individuals? I want to make sure I understand your position. Does there have to be a contract between the individual provider, the person, and docs, or if docs contracts with a facility? So for example, Pathology Services, Inc., will that encompass any person who is providing services for that entity?
So Judge Halligan, I want to draw a distinction between the language of 24A itself versus a contract, because certainly in a contract, the state can provide protections that go above and beyond 24A.
So how else other than a contract could a person be providing services at the request of docs?
So-
A contract, I assume you think qualifies, yes?
Absolutely.
Okay, how
And,
else?
I could imagine some circumstances. So I should note that as the prevailing practice among docs is to have contracts with individual specialists, right? The provision of specialty services are really when docs will call upon specific individuals to provide services. But there may be a circumstance where maybe one specialty is really so esoteric that there's no pre-existing contract, but they could call up that individual and say, we need this particular service. Are you willing to provide it? And that sort of oral request, provided it comes from someone with sufficient authority to really bind docs, we would agree.
But
would
are
be
there
covered.
not any arrangements made with a facility or a practice group? Or are you saying that the only arrangements docs makes are with individual healthcare providers, individual persons?
So the predominant arrangement is to have individual contracts with certain
I
specialists.
thought the federal cases maybe suggested there are a few.
That's right, Your Honor. We are
arrangements
currently
otherwise.
aware of 6, but and so in those cases, it gets complicated because there is contract language. The 2 contracts I'm aware of simply parrot the language of Correction Law 24A and ultimately don't provide any guidance as to what it means to be requested under those circumstances. And sort of, our office has received requests for indemnification pursuant to 2 of those hospitals, and actually,
It sounds a very convenient way to avoid the statute. If your position is, we have to, whether it's expressed in a contract or otherwise, what it sounds to me like you're saying a rare situation, right? Because of a particular type of specialty that you need in a particular case, that you might have someone with authority who reaches out, doesn't, for whatever reason, put that in writing. I don't understand that, but okay, those things happen. Unless you do that, 24A never applies, even though you know that the person you've contracted with is going to have to do something else, is going to either have to adopt another medical expert's opinion or rely on another medical expert's opinion to reach sort of another stage of expert conclusion. It strikes me as not exactly what 24A is allowing the state to do, or docs to do.
so Your Honor, it's important to keep.
I mean, isn't he, let's put it another way, isn't he right when he says you can't have a biopsy without someone actually rendering some medical opinion
And
about the cells?
to be clear, Your Honor, we completely agree with that statement. And ultimately, but when docs request a service, either expressly or implicitly, we are certainly on the hook financially for the cost of those services. And that is an obligation we honored. We paid the bill, which included the pathology services, without objection. But the benefits of Section 24A are quite frankly, extraordinary. They are provided by the grace of the legislature. Defense and
So if your view is, and maybe I'm not understanding it correctly, the 24A encompasses only a docs to individual person arrangement, whether that is in the rare case oral or otherwise pursuant to a contract, how could docs, what is docs' statutory authority to provide indemnification that goes beyond that in a contract?
I'm not aware of any, Your Honor, but perhaps I could use an example of how two divergent contract situations have worked, and that might provide some guidance for your question. So for one of the contracts with a Westchester Medical, Westchester regularly provides an addendum that has a list of practitioners that have been providing services pursuant to that contract. So when our offices receives a request for the protections of 24A, the only thing we really do is look at, is this provider on that list?
So you do enter into contracts with entities, medical centers.
That's right.
And then maybe the contract specifies which of the providers actually fall under the umbrella of the medical center, but the top line agreement is actually between docs and a facility, not an individual. Is
That is correct, Your Honor, and we are aware of six such arrangements.
And this case here, this specific case, was it with the medical center where the biopsy was performed, or was it with the particular provider
It was with,
performed it?
I apologize for interrupting, Your Honor. It was with Dr. Cody, the surgeon. There was no contract with the hospital. There was no contract with the pathology group that employed Dr. Wang or Dr. Wang itself. It was solely with the surgeon.
Who selected the pathology provider?
The pathology provider was selected by the hospital.
They had a contract with the pathology group, Dr. Wang's pathology group, right?
That is correct.
So it's sort of like a non-discretionary, this is who you're going to send the cells to, right?
That's right, Your Honor. Really, docs requested to Dr. Cody to provide a biopsy. We certainly anticipated that certain pathology services would be provided, but we entrusted Dr. Cody to make those arrangements.
But I'm a little confused. I thought you said before you paid for the services.
That's right.
So the services are provided by Dr. Wang in part. Why isn't Dr. Wang then someone who falls under 24A? You've already paid for the service.
We paid for the services, but what he's seeking here is really the extraordinary benefit.
No, I understand that, but 24A says that they get that if they have rendered the professional services. And once you paid for it, how can you challenge it now?
Your Honor, I disagree.
I mean, I could see you paying Cody. I get that, because that's the contract, and that's the person you requested to provide services.
Your Honor, I disagree with the conflation of whether services are requested as being the sole consideration under Section 24A. That would imply that the
Well, maybe I'm misunderstanding your response to Judge Halligan, or perhaps I've misunderstood what she was asking. But if those are not services you requested, how are you able to expend state money to pay for them?
So perhaps I can clarify. What Docs was requesting pathology services, certainly, but it was not requesting services from Dr. Wang in particular. And that is really what takes him outside the scope of Section 24A.
If we disagree with you, what kind of action might you have available to you, right, to perhaps cabin what you I think have articulated very well in your brief as the real potential costs to the state? Are there particular kinds of contracts you could enter? Are there particular kinds of demands you could make of your contractees for their subcontractors? I mean, what happened here is you've got a subcontract, right? That's the problem. They didn't do it in-house.
That's correct, Your Honor. And so in many ways, the outcome will be similar. Docs will proactively go forward and suddenly become a lot more specific in the contracts it enters into. But
And what's wrong with that?
But
Why is that not a good thing?
it would certainly be a good thing, but in the interim, I think there are many permutations where services may not be anticipated, and premising Correction Law 24A on whether the service was implicitly or explicitly authorized would then deprive the state of the ability to make.
Were we to rule against you, how could you, give me an example of how you could draft a contract to avoid the statutory indemnity?
Chief Judge Wilson, are you asking whether the state could say we are not providing any indemnification?
If we were to rule against you in this case, it would mean that we're interpreting at the request of to include services that are a necessary procedure of something you did request, even if the person providing this is something you'd never heard of, right? That if we ruled against you. So in that world, is there a way you could write a contract to insulate yourself from that liability? If there is, can you tell me how? Because I can't imagine it at the moment.
I suppose the only thing I can think would be is like a series of interlocking contracts. So we would then identify every potential downstream provider, the specialties that aren't necessarily client-facing that you would not necessarily directly request. We would then seek out those individuals, have those contracts in place, and then in terms of the specialties that we regularly interact with.
But you wouldn't be avoiding the indemnity in that case. You'd be contractually assuming the indemnity.
That's right, or at least
Yeah, I'm asking, suppose imagine that there's a public policy that's very important to the state not to have to pay for LabCorp or for a pathology outfit that's indifferent about for whom it's providing the services. They're just commercially providing a large service. And the public policy reasons articulated for this statute don't really have anything to do with that because you're not bringing somebody in the hospital who wouldn't otherwise do this work, right? So if you wanted for the state to avoid that liability, and in the hypothetical world I imagine where we've ruled against you in this case, even though you had no idea who this person was, is there a way you could write a contract to avoid that statutory liability?
Your Honor, I can't think of one, but I was.
Well, could you enter, let's take Dr. Cody, that contract.
Yes.
Could you have had a provision in that contract either forbidding this outsourcing of these kinds of tests? I mean, you could have that, I guess. Or otherwise requiring, if they're going to have these subcontracts, that whoever they subcontract with waives this coverage. Is it possible to waive 24A? You could write it in a way that says, assuming without accepting that this would cover it, you waive the coverage. Can you do that, or can a party not, or a potential party not waive?
Assuming there were adequate consideration, I don't see why not, why the state could, in exchange for a waiver of those benefits. I suppose that would be permissible, but I do not have any authority for that proposition, Your Honor.
Yeah, I get it.
Just so I'm clear, is your view that at the request of can only extend to an individual named person, or that it could extend but generally doesn't to a facility?
So in the absence of a contract, our position would be that it is the specific.
No, if you have a contract, what I am asking is, if you have a contract with a facility, is that on its own terms something that can fall within at the request of, or do you read Section 24 as attaching only to a named person that docs could vet if it choose to do so?
I apologize, Your Honor. I misunderstood the question.
No.
So if we read 24A as attaching only to a specific person. So even if there is a contract with the hospital, unless that contract specifies the specific individuals that should be covered, we would take the position that merely repeating the language of 24A would not be sufficient.
What if the contract said the Department of Surgery? Didn't name the surgeons, because maybe surgeons rotate in and out.
So if the contract were with the Department of Surgery at a general.
No, let's just say a hospital.
Yes,
They have a surgical wing,
yes.
whatever they call it. I'm just saying department. If the contract just said the Department of Surgery, didn't name anyone individually, didn't name specific surgeons, does it cover any surgeon who's at the time working in the Department of Surgery, who again provides these services, and then there's a lawsuit?
Unless there is specific language indicating that the indemnification obligation similarly extended to every member of that department, we would take the position.
So what happens with your contracts? Anytime someone is brought in, let's forget about someone who leaves, someone who is brought in to, let's say, one of these groups, they are not covered until the contract is amended, replaced, whatever you need to do. I don't know how you do your contract, so I can't speak to that.
Yeah, so that is the position we've taken with
Rider or something?
respect to the contract for Albany Medical Center, which just has the language of Correction Law 24A and nothing more specific. But again, in contrast, for the Westchester Medical contract, when there is an addendum with those specific individuals, then those protections have been.
That is your interpretation.
That is how our office has dealt with requests for indemnification.
We have not otherwise interpreted the statute in that way.
That is correct, Your Honor. This is the first case to present the meaning of Correction Law 24A. And so unless there are any further questions, we respectfully request that this court affirm. Thank you.
Thank you.
Just briefly, Your Honors, to Judge Rivera's last point about the contracts with the facilities, it begs the question if there's a contract between the Department of Corrections and the facility, but doesn't name any providers, and yet there's indemnification language, well, then who would it cover? I fail to see what effect that contract would have if those benefits aren't going to be extended to the physicians. So if
No, but I thought his point was, I'm sorry.
go ahead.
I thought his point was that there would have to be particular individuals named in the contract, and if they're not named, I thought this was what I was trying to get to in part, even if they work there, even if they did provide some service, that they would not benefit from 24A. I thought that's the position that they were taking.
Correct, maybe I was unclear, but my point there was simply that, well, if they need to be individually named and they're not, and yet this contract still has this indemnification language in it, then what is the meaning of it if it doesn't cover anybody? So if they can, so therefore it would seem to suggest that those providers should be covered if that language is in there. And the last thing I would like just to say quickly is I know there's concern about the fiscal.
I don't know how that helps you, because there's no contract. The contract is with Cody, not with your client.
Correct. I guess my point in saying that is if that's the case, if they're going to do that and indemnify these physicians who are not named in a contract just because of blanket indemnification language between docs and the facility, then why shouldn't Dr. Wang be indemnified here? The situation's no different. The physician's still performing services on an incarcerated person.
Did Dr. Wang, I'm sorry if this is in the record and I've just missed it, Dr. Wang know that this was an individual at docs? Could Dr. Wang have returned it and said, I'm not going to do this? Because I know I won't get indemnified if I get sued?
To answer your question, yeah, no, my understanding is he did not. That would not have been in the record because that was prior to his deposition, his subsequent involvement in the case. This was very early. But my understanding is that he was unaware at the time. Unless you want to have any other questions, I'll submit the rest of my argument. Thank you very much.
Thank you.